The constitutional law question from February of 2003 is one of the most difficult and sadistic questions to appear on this topic. This is a hypothetical that requires us to be able to come up with the issues as a result of carefully reading the fact pattern. You'll notice we've only got a 2-paragraph fact pattern, not including the call of the question. And this is an essay question that is substantially shorter than many MBE questions. Except instead of getting 2 minutes to organize and answer the question, you've got 1 hour. And that means that you will probably either pass or fail this question before you write or type your first word. This is a question that you have to think about and organize carefully. Have a look at the call of the question. It reads, "What arguments could Paul reasonably make that the denial of his Informa Pauperis application violated his rights under the U.S. Constitution, and what is the likely outcome? Discuss." Well, we pause for a moment. We recognize at least that we're in constitutional law, and we see, apparently, a litigant who has sought to get an excuse for filing fees and other costs related to litigation. And we know that the right to have access to the courts is a fundamental right. So, based on the call of the question, we can suspect that substantive due process may be at issue. But that's only a suspicion, and we're going to have to read the facts carefully to figure out what's really going on. So, let's do that. Go to the top of the question with me, and you see in paragraph 1, we meet Paul. He's our plaintiff. He wants to sue Rural, which is a local public school, for violating his rights as a result of denying him the chance to be on the cheerleading squad merely because he is male. Okay, well, we pause right there. We see that there is an equal protection issue at stake, and this is one involving gender discrimination, therefore intermediate scrutiny. Okay, so far so good. We find out also in paragraph 1 that this is an indigent plaintiff who can't afford access to the courts. In paragraph 2, we find out that state law does give commissioners the authority to grant Informa Pauperis applications, which would allow this plaintiff to proceed without the burden of having to pay the litigation costs. He applies for this waiver, and the state court commissioner concedes that the plaintiff has been the victim of an unconstitutional discrimination, but the commissioner still refuses to grant the application because the case involves merely cheerleading. And then we get the call of the question again. So, as I said up front, this is an unusually difficult problem. And the reason it's unusually difficult is because they don't really spoon-feed us anything. If we look carefully at the call of the question, we might be able to anticipate a substantive due process issue, but that's about it. If we read the fact pattern carefully, we can come up with an apparent equal protection problem, but that is more related to the case within the case, since the call of the question is really asking us about whether or not the commissioner has violated this plaintiff's rights. Well, turn the page with me for a moment. Let's have a look at the outline of issues that I've presented. Let's see how we can organize our thoughts about this immensely difficult fact pattern. You'll notice that I lead off with the preliminary issues that are so often present in answers to con law essay questions. I talk about standing, ripeness and mootness, and state action, and then I reach a conclusion. Clearly, this is a litigant whose claims are ready for adjudication. Then you'll notice that I talk about 3 different areas of constitutional rights. I talk about procedural due process with the plaintiff's arguments and a result. Then I talk about equal protection. And here, there are 2 different fundamental rights at stake. A possible access to the courts issue, and then a freedom of expression issue relating to this plaintiff's underlying claims against the school. So, you'll notice I talk first about the gender discrimination claim, but I am actually more interested in the fundamental rights theory. And this is what makes creating a good answer to this question so hard. We've really got to think carefully to understand and to explain the rights that this plaintiff seeks to litigate. After equal protection, we enter a substantive due process analysis, and we see that Paul's arguments are going to relate both to the fundamental right of access to the courts and the fundamental right of freedom of expression. Ultimately, I'm going to find in favor of this plaintiff, and I'm going to find against the court commissioner. Now, turn the page and let's have a look together at the model answer that I have written and presented to this very hard question. You'll see, up front, I go into a fair amount of depth about what happened. And you'll see, in the first couple of paragraphs, I indicate that it's possible that this plaintiff could have brought these federal claims in federal court. But we are not asked about that directly, so I only spend a moment on it, and then I turn to the basic issues of standing, ripeness and mootness, and state action. By the end of page 1, I've concluded that this plaintiff does have the right to litigate the claims that he wants to bring in the forum in which he wants to bring them. And then I move on to consider the constitutional claims. I begin with procedural due process. You'll notice, for a change, this time I lead off with the law. I spent an awful lot of time setting up these issues on page 1. For page 2, I start off by explaining procedural due process in a reasonable amount of depth. After that, I move on to Paul's arguments. And it seems quite evident that the commissioner's decision is arbitrary. And as a result, that constitutes a violation of this litigant's right to procedural due process. So it isn't hard for me to reach the conclusion that the state court commissioner's denial of this plaintiff's application to proceed in forma pauperis is a violation of his right to procedural due process. Then I move on to consider the equal protection claims. And in this instance, I point to two different discriminations. First, the discrimination by the state court commissioner on his fundamental right to access to the courts. And then, in the underlying case against the school district, this plaintiff has a fairly persuasive First Amendment claim for free expression as well. So, taking a step back, we see how important it is to organize our thoughts carefully. This is about as complex a constitutional law analysis as we can be called on to provide. And, once again, we've got to come up with these ideas based on our interpretation of the fact pattern, as opposed to being able to organize our answer based on the court and the examiners telling us in so many words that the plaintiff's theories relate to A, B, C, and D of the U.S. Constitution. Here we've got to come up with it ourselves, and that's what's hard. Next, I turn to the equal protection argument, and you'll see in a fair amount of depth I go into Paul's claims, both with regard to the court and with regard to the school. After that, I turn to a fundamental rights theory, and I conclude that the plaintiff has a very strong case. Here, too, more or less across the board, he's got a good case. It may be true that I have something of a pro-defense bias, but when a plaintiff comes like this and makes as persuasive a case as this plaintiff does, I don't hesitate to find for that plaintiff more or less across the board. Now, let's turn to substantive due process. This analysis, intellectually, is pretty much an echo of what we've talked about before. But we see again, access to the courts is one fundamental right. Freedom of expression is another fundamental right. My conclusion is, once again, this plaintiff has established a fairly persuasive constitutional claim. So, at the very end of the paper, I conclude that the state court commissioner's denial of Paul's in forma pauperis application violated his due process and equal protection rights, and I indicate that the plaintiff likely will prevail.